any outstanding issues and then work to resolve them before reconvening on this bill on Thursday, at which point we'd be in a position to, I hope, I'm not counting any chickens till they hatch, to be able to vote the bill. There is a fiscal note being prepared for it, and we're not going to hear from the JFO until Friday, but I don't think that will be a problem for the bill, because the normal procedure for any appropriation that would be recommended is that the bill would travel to appropriations. The funding of the appropriation will be stripped, set aside until later in the session when the big bill is reconciled, and then funding would be reapplied to the bill as part of that sort of end of session negotiation. So I wouldn't want to hold up the bill for lack of the fiscal note, and it's in development. I think it's just taking a little longer than people thought, and I think that's in part because there are a lot of different departments that need to be consulted as part of developing that note. So I don't see our counsel yet. And with that, so let me just check in with our committee assistant and see if you've heard back from Ms. Schakowsky.
I have not. I just emailed her again.
Okay, that's all right.
I'll continue checking and let you know. She may have been listed, excuse me, Senator Bray, she may have been listed last on our agenda originally.
Right.
So I'm trying to see what time she is planning on attending, because we changed the order.
It takes more than a hiccup to stop the committee. So off we go. So let's go to a plan B. I'm just trying to, Ms. Mahali, do you have 3-2 or 3-1 in front of you?
I have 3-1 in front of me. I have not, oh, looks like you have Ms. Jakowski with you coming on.
Right.
I have 3-1 in front of me. I could go to the website and try and pull 3-2, but I had made some notes on mine. And so if all the difference is a comma, then I was just going to keep mine pulled up.
Same here. So, okay. So good morning, Ms. Schakowsky. I just wanted to double check, because I had printed out for myself, as have others, the 3.1 draft, and is 3.2, which is available now. Essentially the same thing, but it's gone through the editorial office for proofing.
Yes.
Okay, great. So if you can walk us through, please, 3.2. And I'm guessing there'll be very few differences between that and 3.1, and nothing substantive in terms of the content of the bill. So is that fine, or am I missing something?
No, that's fine.
Okay, so let's go with 3.2, and if you could walk through and explain the most recent round of changes.
Sure. The findings section is entirely new. They're now the findings that were provided by CLF. Do you want me to read through them?
No, I think we could. I mean, I would ask committee members to read through, but let's go right to the working parts of the bill. Not that the findings aren't important, but just that concentrate on the parts that get the job done, sort of.
Sure. Did you want me to put the bill up on the screen?
Yes, please.
Okay. Okay, so then the new changes begin on page 6. Why isn't this working? Okay. Page, can you see the bill?
Yes, thank you.
Yep.
So page 6 starts the text of the statute on environmental justice. So first, the first definition is environmental benefits. There was conversation last week about this definition. So a small change has been made, changing the word resources to assets and services. So environmental benefits means the assets and services that enhance the capability of communities and individuals to function and flourish in society, etc.
That was the last, most recent attempt at coming up with a phrase that meant something, but invited, wasn't overly specific. Anyone has other suggestions or open to it, but thank you.
There's a small change in the definition of environmental burdens. It really is, I think, grammar related. So environmental burdens at the bottom of page 6, environmental burdens means any significant impact to the clean air, water, and land, including any destruction, damage, or impairment of natural resources resulting from intentional or reasonably foreseeable causes. Examples of environmental burdens include, and I'll jump down to activities that limit access to green spaces, nutritious food, indigenous food, or cultural resources, etc. So this is, Senator Bray, I think this actually might have been one of your changes as well.
It was just awkward to read indigenous food or cultural resources and then nutritious food.
Oh, that's right.
So we
swapped
just
that.
flipped them. The content's the same.
Moving down on the page, there's again some small grammar tweaks in the definition of environmental justice. So environmental justice means all individuals are afforded equitable access to and distribution of environmental benefits, equitable distribution of environmental burdens, fair and equitable treatment and meaningful participation in decision-making processes, and the development, implementation, and enforcement of environmental laws, regulations, and policies. New sentence. Environmental justice recognizes the unique needs of individuals of every race, color, income, class, ability, status, gender identity, sexual orientation, national origin, ethnicity or ancestry, religious belief, or English proficiency level. And environmental justice, and it goes on. So those are small changes for readability, really. Okay. Next.
Mr. President, may I just, Ellen, would you prefer that we ask questions and make comments as you go along, or would you prefer that we wait till you're done?
I'm fine with questions now. I don't know what Senator Bray's plan was. But
Might as well address them as we move through them. Thanks.
Okay,
Please.
I think I'm going to be a language maven here. Unique needs. I think there are particular needs, but unique means it's the only one in the universe. And I think we probably ought to not use the word unique. I realize it has come to, I know from my students, unique has come to mean unusual, but that's not what it means. You look at it, the UNI part at the beginning of it, it means the only one in the universe. And for all eternity, for that matter. It's unique, it's one of a kind. So I think what we need to say is special or particular or something like that.
Okay. How about particular?
I thought the meeting needed a little nitpicking. So
okay. Particular works for me. Anyone else comment on that one? Okay, particular needs. Thanks.
Makes sense.
Sure. Okay. So on to page 8. Again, a small change on page 8 in the definition of environmental justice population. So this language hasn't changed from the prior draft, but above, people was changed to persons to match its use. Above, this was recommended by the editors. So everywhere else we've used persons except for also in this sentence. Do you want me to read this definition or?
Nope.
Okay.
Meaning straightforward still.
Next, in the definition of meaningful participation, there's again a small change. I think this was a recommendation from Senator Bray.
Yeah.
In the second sentence, meaningful participation also integrates diverse knowledge systems, histories, traditions, languages, and cultures of Indigenous communities in decision-making processes.
Okay. Any questions? Onward.
It requires that communities are enabled and administratively assisted to participate through education and training. And then on to page 9. Meaningful participation requires the state to operate in a transparent manner with regards to opportunities for community input, and also encourages the development of environmental, energy, and climate change stewardship. So this, I think Senator Bray had asked if I could just restructure this sentence. So the words are just reorganized, reordered in this sentence.
Right, thank you.
Chair Bray.
Yes, please.
Yes, for the record, Caitlin Ellerman, Agency of Natural Resources. I wanted to flag that Commissioner Walk is apparently in the lobby and would be happy to join at your and Ms. Newman's convenience.
He's been let in.
Thank you.
Okay,
you very
thank
much.
you.
Sorry about that.
No problem. Thank you for, takes a village to write a bill. So thanks for jumping in, getting someone in the room on time. Please continue.
Sure, so on to page 10. So now we're out of the definition section and we're in section 6002, the section on the state environmental justice policy.
Right. And so one thing to pause, I think, and let people know is there was a definition omitted from this draft. And so it's hard to see that left, but it was the definition that I think was people were struggling with a little bit, and that was overburdened and underserved communities. So I'm it's not easy to see that it's not there because the new draft moves right on past it. So maybe others will want to come back and talk about that later. So yes, please, if you can continue.
Sure, so subsection C on page 10, small changes here in the first sentence, removing that defined term you just mentioned. So it now reads, on or before July 1, 2025, every Vermont state agency shall create and adopt a community engagement plan that describes how the agency will engage with environmental justice populations as it evaluates new and existing activities and programs. So the change there was the striking of the reference to engagement with overburdened and underserved communities.
And also flag for folks that just prior, there is in section B, there's a list. This is one of 3 lists in the bill about departments and agencies in the mainline government that are participating in one way or another. And we're having Susanna Davis in on Thursday, and there's a question of in what lists does it make sense to include the Office of Racial Equity? So we can come back and talk about that one again. But just wanted to flag it while we're going by.
Okay. On line 4, there's new language that was proposed last week. So community engagement plans shall align with the core principles developed by the Interagency Environmental Justice Committee pursuant to subdivision 6004 C3B of this title, and take into consideration the recommendations of the Advisory Council on Environmental Justice pursuant to 6004 C2B of this title. Next, down at the bottom of this page in subsection E, on or before December 15th, 2022, the agencies of natural resources, in consultation with the Interagency Environmental Justice Committee and the Environmental Justice Advisory Council, shall issue guidance on how agencies and departments must determine which investments provide environmental benefits to environmental justice populations. A draft version of this guidance must be released for a 60-day public comment period before being finalized. So this language and the language I will continue to read was proposed last week as well. So you heard testimony on this. On or before July 1, 2023, all agencies and departments listed in subsection B of this section shall, in accordance with ANR's guidance document developed pursuant to subsection E, review the past 3 years and generate baseline spending reports that include where investments were made and which geographic areas at the municipal level and census block area, where applicable, incurred environmental benefits from those investments, and the percentage of overall benefits from those investments that resulted in environmental benefits in environmental justice populations. I feel like incurred may be the wrong word on it on line 11. But maybe okay. Okay. Agencies and departments shall publicly post the baseline spending reports on their respective websites. On or before July 1, 2024, the agencies and departments covered under subsection B of this section shall direct investments to environmental justice populations with a goal that at least 55% of the overall benefits from those investments go to environmental justice populations. So do you think you received testimony last week that the 55% of spending should be changed to a goal?
And thanks for, I was a little slow on the mute button. The where you flagged incurred, which sounds more like a debt rather than a positive thing coming your way. How about if we just changed it to received?
Yep. Higher up on this page, also, I think the musts will be, I need to change those to shalls. We don't use must in drafting, so I missed those, so I apologize.
No problem.
But same meaning.
Thank you.
Mr. Chairman, may I? Thanks. The percentage requirement, has any thought been given to, and I'm not trying to answer my own question one way or another. It's a genuine question. Would that likely bring us into some trouble with federal civil rights law and even with the 14th Amendment?
May I ask Senator McCormick to repeat that question?
Yeah, the requirement that a certain percentage, in fact, it's more than half, be allocated to particular identified groups. And again, I'm not answering my own question. It's not rhetorical, it's an inquiry.
Sure.
Could that bring us afoul of federal civil rights law and even of the 14th Amendment? I think that's sort of a gray area, because I've seen court cases go both ways on that preferential treatment issues and affirmative action and acceptance of colleges and so on. What kind of ground are we standing on, as far as you know, Ellen?
I don't know. I haven't looked into it. I don't know if it would be the 14th Amendment.
Yeah, we're talking the 14th.
Well, equal protection of the law.
I don't know. I haven't looked into it.
All right, so, and we will hear from both CLF and ANR in this draft. So after we can all double back to the same question, and let's flag it for now. So thank you, Senator McCormick.
Okay.
You don't want to run afoul of the law while trying to do something proactive. Okay. All right, so let's continue the walkthrough, please.
Onto page 12, subsection H. On or before July 1st, 2025, and annually thereafter, all agencies and departments listed in subsection B of this section shall issue annual spending reports that include where investments were made and which geographic areas at the municipal level and census block group, where applicable, incurred environmental benefits for those investments, and the percentage of overall benefits from those investments that resulted in environmental benefits in environmental justice populations. Agencies and departments shall publicly post the annual spending reports on their respective websites. This language is very similar to the language on the prior page, but I do believe it's a slightly different issue we're talking about. On or before December 15th, 2025, ANR shall submit a report to the General Assembly describing whether the baseline spending reports in subsection F of this section indicate any municipalities or portions of municipalities that are routinely underserved, as determined by a finding that those areas receive, averaged across 3 years, a significantly lower percentage of environmental benefits from state investments as compared to other municipalities or portions of municipalities in the state. This report shall include a recommendation as to whether a statutory definition of underserved community or any other revisions to this title are necessary to best carry out the environmental justice state policy.
Thank you.
On to page 13, 6003, the rulemaking section. This, I believe, merged these two paragraphs so that the rulemaking now includes the environmental justice mapping tool. So on or before July 1, 2024, the Agency of Natural Resources, in consultation with the Advisory Council on Environmental Justice and the Interagency Environmental Justice Committee, shall adopt rules to define and implement consideration of cumulative environmental burdens, including how the public and state agencies shall use the environmental justice mapping tool as required in subsections 6002 and section 6005 of this title. And so I think the prior draft had those on separate rulemaking paragraphs. And then next, down at the bottom of subdivisions, subsection C, the Agency of Natural Resources, in consultation with the Advisory Council on Environmental Justice and the Interagency Environmental Justice Committee, shall review the definitions of environmental justice population and overburdened and underserved community every 5 years and recommend revisions to the General Assembly to ensure the definition achieves the environmental justice state policy.
Okay.
On to page 14. Prior to drafting new rules, agencies shall consult with the Environmental Justice Advisory Council to discuss the scope and proposed content of rules to be developed. The agency shall also submit draft rulemaking concepts to the Advisory Council for review and comment. Any proposed rule and draft Administrative Procedure Act filing forms shall be provided to the Advisory Council not less than 45 days prior to submitting the proposed rule or rules to ICAR.
So I'll just note in passing that this section replaces this sort of notice and consultation prior to going into the formal APA part of rulemaking. Replaces an earlier version in which the Advisory Council needed to approve the draft rule prior to its submission to ICAR by a supermajority vote. So this, I think, is more in line with existing practice. And then I'll just note that once formal rulemaking begins, then there is, again, notice and comment all within the APA. There's a full notice and comment period to follow.
Okay, section 6004. This is the section that establishes these new committees, the council and the committee. So first on line 14, this is where the language creates the committees. First, there is created, there was language here about by when the committees had to be created. That language has been moved to the next page. So there is created an Environmental Justice Advisory Council and the Interagency Environmental Justice Committee. Onto page 15. Appointments to the groups created in this subsection shall be made on or before October 1, 2022. So the prior draft had referenced within 90 days of enactment, and we don't normally, the drafts don't usually use that language. There's usually a date certain. So I inserted October 1, 2022, but as an approximation from 90 days of from July 1, 2022, but you can pick the date by which you'd like the appointments to be made.
Thank you.
And the next change is all the way on page 17. And this is adding the details of the responsibilities of the Interagency Committee. So the Interagency Committee shall consult with ANR in the development of the guidance document on how to determine which investments provide environmental benefits to environmental justice populations. And on or before July 1, 2023, develop in consultation with ANR and the Environmental Justice Advisory Council a set of core principles to guide and coordinate the development of the state agency community engagement plans required under 6002. And that the name of the council needs to be fixed because I think it's slightly different, but yeah, no, maybe that's what we went with. Just kidding. Ignore what I just said. Okay, and the two final small changes, well, maybe not small changes. Page 19. The members of the Interagency Committee. So the prior draft had 11 members of the Interagency Committee. This draft has added the Director of Racial Equity or designee, as requested by Senator Bray. I will point out that the Advisory Council does already have the Director of Racial Equity, so I think you were considering whether or not that position should be on both committees.
So we'll hear from Ms. Davis directly on the question, but it did seem as though, in particular, given her unique position, that she might serve as a liaison, besides being a full-fledged member of both committees. Having someone who serves on both in common might be a valuable sort of liaison function. So, and that's open for discussion. That's the thinking about having her join the Interagency Committee.
And then finally on page 21 in section 3, there's a small change. So the annual report, I've added reference to the departments in addition to the agencies. So beginning on July 1, 2023, the agencies and departments listed in 6002B shall issue and publicly post any annual report summarizing all actions taken to incorporate environmental justice into the agencies or departments' policies or determinations, rulemaking, permit proceeding, or project review. And I will point out that there's still, I think, you know, the section 4 is still blank. If you're not going to insert anything here, I'll need to do a new draft so we can take this out before you vote on it.
Okay. So thanks for that. I'll put a flag on it right now and consult with appropriations. So thank you very much for the walkthrough. Thank you for drafting. So, you know, the process has been the same all along, that Ms. Mahaly and others are consulting about changes, and as has ANR has been also reviewing. And then there have been, happily, I want to thank both parties for continuing to meet outside of committee time to bring forward suggested language. It really helps us make progress in a much more timely way. Since you're both in better positions than the committee to represent the interests of your parties. So with that, I'd like to do 2 passes through and one, Ms. Mahaly, I think if you want to, using this current draft, highlight anything, talk about changes made. I think from a certain point of view, it might be, you know, concessions were made, agreements were made, changes were made structurally. So just want to give you a chance, if there's anything you want to draw the committee's attention to point them out to us in the draft. And then we'll go to Commissioner Walk. Same offer.
Sure. I just want to defer to Commissioner Walk if you had a timing constraint that you wanted to go first. I'm happy to go second, but otherwise I'll carry on.
My timing constraint was on the front end as per my delay in arrival. So please, by all means, go for it.
All right. Thank you. For the record, Elena Mahaly, Vice President of Conservation Law Foundation. Thank you for the opportunity to join you all today and walk through this most recent draft. And thank you, Ms. Jakowski, for your drafting. Just to be clear, while we did transmit the updated version of the findings, those were drafted by the Vermont Law School Environmental Justice Clinic. They were the ones that drafted the original findings. And just since there's been a year since the first version was introduced. They went back through and just revised them based on updated studies and made sure that every finding has a citation so that it's not a statement of opinion, but one of fact grounded in citations. I did want to just note on page 7 of 3.2 on line 15, it looks like maybe there's an errant of. It says environmental justice recognizes of the unique needs. Just would remove that. On page 13, sorry, just scrolling in my draft. On line 21, there's still a reference to the Agency of Natural Resources every 5 years reviewing definitions, and we no longer have a definition of overburdened and underserved community, so I would strike that. The belief is that with regard to underserved communities, because they will be reviewing the definition of environmental justice populations, they will be in a place to bring into that definition any individuals who are overburdened by environmental harms and are not covered. And with regard to underserved, that's now dealt with later in the bill with them reporting back to the General Assembly whether that term should be defined.
Okay.
The next section, and this is probably my largest piece of feedback, is on page 14, starting at line 3 with D. As you noted, this has been significantly changed. Before this comes down to how do agencies have to listen to and incorporate feedback from the advisory council when they're adopting rules to implement this policy and this law? And ultimately, what we had in the former version of the bill was giving this advisory council the ability to actually vote to approve rules. It was a step beyond what we have done in other rulemaking processes, and that was out of a recognition that this is a unique circumstance where we have a bill that is specifically about trying to have better, more meaningful representation of impacted and disadvantaged communities in our state decision-making. And to be quite frank, I mean, an agency can consult all it wants with an advisory group and receive lots and lots of feedback and then just make the same decision that it was always going to make. It can completely ignore the advice and feedback of this advisory group that we have established in law and asked all of these people to take their valuable time and spend reviewing materials and provide feedback. And as you heard from witnesses on day one of taking testimony on this bill, particularly I recall Ms. Kaya Morris, you know, it's problematic if we just keep the status quo in this bill of always having an advisory council that is just giving advice into a vacuum. There needs to be some crosswalk, some safety mechanism, some in this legislation that sets it apart and says, we acknowledge that this advisory council is specifically tasked with helping bring to the fore voices that have not been heard from, and that we're not just going to hear their voice and move on like we were always going to be making the decision anyways, but we're going to actually be tying ourselves to listening to that group and letting that group actually influence the outcome of our decision. So that's why the language that was in here before that has been struck was effective in doing that, in terms of the language said that if less than 12 members of the advisory council vote to approve any proposed rule, that is, if there is a majority of members that disagree with what agency is proposing in the rule, then the agency has to go back and they have to reformat the rule to account for those comments and concerns that the advisory council raised. It was not I believe it was 12 out of 17. And I want to offer a compromise solution for this committee to consider. As the language was before, it let this council, it had this council approving any rule that was promulgated to carry out this environmental justice law. Really, there is one fundamental rule that is listed in this bill that is going to be core how this policy is rolled out, and that is on page 13, line 2. You have section 6003A1, and that is where the Agency of Natural Resources is defining and implementing consideration of cumulative environmental burdens. This is really the meat of this whole law, is how are agencies going to be factoring in cumulative environmental harms when they're making decisions about environmental issues in communities. And if this advisory council is at least given this approval authority over that one rule, I think that would go a long way in showing that we really mean it when we say that we're setting up this advisory council to take advice and act on that advice. Otherwise, it's just going to be treated like every other advisory council, which sometimes means that that advice is not listened to and not heard. And I believe that the process of what we have here in the version of A&R, kind of discussing the scope and proposed content of the rule and submitting a draft to them for feedback, that all should happen too. And if that's done well, and if they truly are, having an iterative consultation process and they're listening to the feedback, ultimately the vote should not be a threat. It should be something that is a given and that is a safety mechanism that makes the advisory council members feel empowered. So that is my pitch for revising D to at least keep the approval authority, the voting authority of the advisory council, but potentially just limit it to the rule that is discussed in 6003A1, which is about cumulative harms when rulemaking.
Okay. So thank you for that. And so let me ask a quick question. So I'm trying to understand, and I would ask our own council the same question, which is, since we have a system of representative government, how do we have a group of unelected individuals serving in a capacity that controls the administrative branch of government? I'm not sure how that, and in essence, that's what we're giving that body, the advisory council, that power. So I think that's no matter where I fall on wanting, of course, I want, and I think everyone here wants that advisory council to be respected and their advice incorporated into the rulemaking. But in terms of the legal structure, I'm just trying to understand how that would work, and if you have any concerns around the legal status of empowering a board that way of unelected appointees.
I understood you to be asking Ms. Chakowski first.
Yeah, start with Ms. Chakowski, and then I figure since it's your construct, we'll come back to you. So Ms. Chakowski, I don't know if you've looked into that question.
I have not fully looked into that question. I do think that is a concern. Rulemaking authority comes from the delegation of legislative rulemaking to an agency provided in statute. I haven't done legal research on this issue, but I do think that a further delegation to an unelected body could raise concerns about violation of that delegated authority, but I haven't looked into it.
I mean, I suppose you could say, well, it's provided for statutorily here. So maybe that addresses the concern, but so if you could continue to look, and then let's go to Senator Campion.
Thanks, Mr. Chair. Ms. Mahali, would you mind, I see these kinds of things happening, for example, with the State Board of Education. We give them certain authority to do certain things. They too are an unelected body. They're appointed by the governor. There are other things, but how would you differentiate? Because there does seem to be a difference here between, a group that's in statute, such as the State Board, we could even say our Fish and Wildlife Board, and what we're trying to do here.
Well, I would first just say that this is not novel. CLF was instrumental in helping Massachusetts enact its environmental justice law, and there they have done exactly this. They have given the advisory council, which was created by statute and is made up of members of the public who have been appointed by the governor. They have given them voting authority over their rule that defines what environmental justice population means.
Okay.
So they are doing that there. So this would be a model of that here in our law. Second, I would just say that what's different is it's not delegating authority to this advisory council. ANR still is the one that is rulemaking and that is ultimately putting the rule forward. What it's doing is it's just it's putting in statute or a sort of a requirement that they actually have to account for at least a majority of the advisory council members' concerns when they're drafting that rule. It's kind of a crosswalk provision that similar to, when you have provisions of law that require a community to adopt a certain plan and you require that that plan be consistent with certain statutory factors. Like this is the same idea that rules are going to be approved by and consistent with the advice of the council.
So it's very narrow authority, really.
Well, that's what I'm proposing as a intermediate here, because I could imagine there's concern if all of a sudden we're opening Pandora's box of this advisory council needs to vote on every single rule that may touch environmental justice. But here we're saying this one rule in statute, because of its nature of trying to address the very fact that many underrepresented Vermonters have not had an opportunity to be heard, that this is a scenario where we are going to really empower the advisory council and show through this not just symbolic act of creating the council, but actually having language in statute that requires the agency to incorporate their feedback in the ultimate outcome of their decision. And yes, this will go through the whole formal APA process afterwards. But
had Massachusetts done this before with anything else, or was this sort of the first step they took? In other words, is there sort of historical precedence for them using this kind of process with other things?
I don't know the answer to that, but I do know that when the bill was,
because some states, it's more part of their culture. They might, have these kinds of things. This is somewhat new territory for us. So I
think that it was partly, it may have been new for them, but they felt that it was so core to the concept of environmental justice to have those voices not just be heard, but also acted on and listened to and incorporated, that was what was motivating them. And I would urge this committee to kind of view this in the same light, that if we are going to take an exception and do something different, this is a great situation to do that and to show that this is more than lip service to an advisory council.
Thank you.
All right, so we should learn more about the legal background. I think honestly, it's a little troubling to characterize it as the potential to be nothing but lip service, because I don't know that treats all the parties as coming together with a genuine intent to work well, but.
Yeah, I agree.
And I'm sorry if that sounds hyperbolic, but this is how it feels. I am channeling feedback that I have received from many
Sure.
people who have served on advisory councils in Vermont who don't feel heard.
Right.
So that's where I'm coming from.
Okay, well.
Not to reflect on the intent, which I know is absolutely genuine, of the agency to engage with this council, but I'm trained to, think of sometimes what happens when intents are not executed on, and we want to make sure we have safeguards that fundamentally require the adoption of the concerns here.
Sure. And I'm not, I'm just trying to be even-handed about how we examine the process. Senator McCormick.
Thanks, Mr. Chairman. I think that anyone with even vaguely progressive politics knows exactly what it feels like to be heard out and thanked for your advice and then completely ignored. And I would hate to see this advisory council get into that position. Having said that, I'm also troubled about us empowering the council to basically write rules that have the power of law. The rules in question, they come before LCAR already, right? Any of the rules we're envisioning would be subject to the Legislative Committee on Administrative Rules.
That's correct.
Right.
Okay,
So
I'm wondering about giving the advisory council some teeth without just basically delegating rulemaking to them and de facto. What about a rebuttable presumption before LCAR that if they think the rule is not a good rule, that's the starting point. It's up to the agency to prove otherwise.
Okay.
I mean, or something along those lines. I would like to give this body some real teeth. I'd like it to have real weight. I don't want to water down its authority. On the other hand, I think a case can be made that it's hamstringing administrators who have a job to do and who were appointed by someone who was elected. Of course, so is the advisory council, but I would like to give them some kind of teeth. Thank you, Mr.
Right.
Chairman.
It's not. Okay, so we'll
Maybe
hear
we
more
can
from this, and we haven't heard from Commissioner Walk yet on this one either. So why don't we continue on, flag it? This is a major point to be sorted out. But so we'll come back to it. And
Sure, and I would say that is the major flag for us.
Okay.
Remaining. So I think I have 3 more things that are just smaller. So
Okay.
happy to revisit that and revisit the senator's idea. The next thing I was just going to suggest is on page 17, when line 4, there's new language about the duties of the interagency committee. I just suggest a cross-reference in subpart A to instead of just saying development of the guidance document. I think that could be a little bit confusing as to what guidance document is being talked about. So I recommend a cross-reference to section 6002 subpart E, which is where this notion of a guidance document is first raised.
Thanks. Thank you.
I think actually the last thing I wanted to address is Senator McCormick's comment about the 55% number and whether that's something that you need to be concerned from a constitutional perspective. It is our opinion that you are effectively insulated from any constitutional challenge because of 2 things in this bill. One is there are multiple factors that make up what an environmental justice population is. It is not just a situation where you're saying distribute this based on race. our environmental justice population definition has 3 factors that make up the population: race, limited English proficiency, and income. And it is an amalgamation of those 3 things that make up this population. So there's not a direct tie. So the fact that there are multiple factors there, also the fact that this is a goal, it is not a requirement. So those are just a few things that from our research and our perspective make this so that I don't think it's necessary to make any changes based on fear of constitutional challenge.
Mr. Chairman, I thank you for that, Madam, for that answer. I just want to reemphasize that my question was a genuine inquiry. It was not a rhetorical question. I'm not of the opinion that this was unconstitutional. I'm anticipating possible problems down the road.
No, it's a total logical question to ask with anything related to percentage and race and benefits. So I think that that actually wraps up the issues that I want to talk about. So I hope that we can spend more time talking about how to give this council legitimate opportunity to meaningfully shape the outcome. If it's not in the version of voting, we can discuss other ideas. Thank you.
Thank you. One idea that occurred to me as we're talking about it is if rather than simply receiving the recommendations of the council, there was, just as in notice and comment, there was a written response to suggestions that were proposed but maybe not used, like so that you might say it's a more thorough or deliberative or at least explicit response, as opposed to the sensation of having spoken, been heard, and ignored. But it may be too subtle. I don't know if that's a more, if that's helpful. Anyway, I'm just going to float that one out there, and let's go Commissioner Walk. So the floor is yours. We have a new draft in front of us. Happy to hear your thoughts on any and all things you see in it that you want to comment on.
Thank you, Mr. Chair. For the record, Peter Walk, Commissioner of the Department of Environmental Conservation. I'm going to withhold some sort of editorial comments. I mean, there's some pieces in here that I think need some typo checks and just to clarify things. And so I would appreciate the opportunity, if we can, to one of our attorneys work with Ms. Chakowski to clarify some things. I think there's just some pieces that are a little odd. So I'll stick to sort of the high points if that works for the committee.
Right. And I'll say to Mr. Chakowski now, please do work with Ms. Ellerman or Ms. Stevens, whoever you're working with. Thank you.
So I appreciate the changes that have come about in this draft. I think this bill is really getting to the point where it's something that ANR is supportive of. I think there are obviously the sort of key feature that we haven't really addressed in this is the fiscal note that you've asked for. I want to clarify that we have worked with JFO to provide some input to that process. So look forward to your review because that is a critical feature to making this successful ultimately.
Well, thanks for that. And I'll just say it again to sort of broadcast it to any operating area that's reviewing 148, that we don't expect anyone to do more, take on new duties with no support. So if the bill entails hiring or whatever it is in order to successfully implement it, we certainly want to know what the bill is so that we can make the case to appropriations. Thank you.
Right. So I wanted to flag a few things first. So in 6002, in 6002B, I think there is a omission that we've noted that you may want to fix. in the agencies listed to be required to address cumulative environmental burdens, you have not listed the Agency of Natural Resources. And it is my presumption that that is an unintentional omission, and one that we would like to flag for you.
Yeah, we want to invite you to the party. So can you give me the cross-reference so I can catch up on my draft here to make sure?
Sorry, I'm looking some overall notes. It's in 6002B.
I think it's line 18 on page 9.
All right, got it. Thank you. Consider yourself invited. All right.
It would be awkward for us to write rules for everybody else and then not be a member of the participant in the party. So thank you.
Could be super convenient to write rules for everybody.
I don't, I'm not gonna mess around in that soup with my fellow agencies. Thank you. One of the things that as some of the pieces around how the funding pieces and other things have shifted over time, I want to flag something that I think is a bit of a sort of process timeline perspective. You've asked for the committee, the interagency committee and the advisory council to be seated and in place by October 1 of 2022. The first piece I would like to flag for you is that as we've been advised by other states, may not have occurred by then. That Washington is 7 months past the passage of their legislation and they do not have a seated advisory council. And so to ensure that there is time for that, I just want you to sort of be aware that other states have struggled with the actual seating of individuals because of the things that you're asking of them and the time commitment that you're asking of them. And that relates to some of your questions about how do we deal with per diems and appropriate compensation for the work. However, that also then relates to some very specific actions that you've requested of state agencies related to specifically to the funding component. By December 15th of 2022, which is for those following along at home, effectively 75 days after the council will have been seated, we are to issue guidance that will have consulted with both the council and the committee and gone through a 60-day public comment period. I think that we are capable of some excellent timely work at the Agency of Natural Resources. I don't believe that's possible. At the same time, I don't think, because of the way in which we've adjusted the overall timelines around this funding goal to reflect the reality of the state budgeting process and the timeframes that it would take, that kicking that deadline back 6 months doesn't actually slow us down any. And then to kick back the actual first report back 6 months, so it still gets to you prior to the start of the next legislative session. We collectively should want to get the environmental benefit discussion around funding right the first time, so that we can actually speak to Vermonters about what we assess the environmental benefit of different activities to be, and to tell them where that funding has gone. If we rush that process and get it wrong, that report will be of little to no value. So in my mind, this is a bit of a go a little bit slower at the beginning to get to the ultimate end, with that the deadlines of July 1, 2024 and July 1, 2025 not needing to change. So it would be about the initial guidance, and then that first report doing the 3-year look back should be each delayed 6 months, or effectively 6 months.
Can you and your colleagues put together a timeline, a workable timeline, and then we can cross-reference that to where those dates occur in the bill, and then consider making those edits?
Yes, we can. But I wanted to flag, given that was sort of a broader, it does not a line by line discussion, I wanted to make sure I walked you through that in full.
Sure. what do they say? Well begun is half done. So let's not rush the beginning.
Yes. Then on page 11, line 13 and page 12, line 7, there's reference to a statement that is a little bit unclear in my mind. It says percentage of overall benefits from those investments that resulted in environmental benefits in environmental justice populations. It is a little unclear to me what that means and how we would evaluate it and what the scope of that is. And so it matters because obviously we're presenting sort of what the percentage is. So is that simply a percentage of the investments, or is it a what percentage constitutes an environment? There's a lack of clarity there that I think is unintentional and one that we want to try to resolve. That makes, if I'm making any sense.
Yeah, I'm scanning back through the document, looking for the language you just cited.
So it's on both there. It is in both, in a couple of different places, page 11, line 13 and page 12, line 7.
Okay, thank you.
So I can read it in its broader context if you'd like.
No, I can see how, well, we should just propose, yeah, I was going to say, Ms. Mahaly, do you know what you were aiming for? So
Yeah.
why don't we
Do you
go to
mind if
that?
I respond?
Yes, please.
So I think that the really important point here is that when we talk about 55%, we're not necessarily constraining it to dollars. Saying that benefits flowing from investments, you could measure that in dollars, but you could also measure it in terms of number of environment, like electric vehicle charging stations, or number of quantity of acres conserved of wetlands from a climate mitigation standpoint. Those are the details that ANR is going to iron out in its guidance document, is exactly how to quantify the environmental benefits that are flowing from investments. If ANR chooses to just have that be a dollar-to-dollar assessment, so be it. But the language here was trying to leave that open for the agency to determine at a point further down the road when it's been able to learn from other states engaged in this process. And that draft guidance would then go out for public comment so that others could weigh in. So this is really intended to be talking about this in a broader framework.
So I might suggest that it simply be, if you would accept a friendly amendment to the idea of that, it simply say the percentage of overall benefits received by environmental justice populations. I think that says the same thing, but a little more clearly.
Thanks. Ms. Schakowsky, are you keeping track? So let's mark that as a change to be made, and we'll have that in our next draft, please.
That makes sense with me.
Thank you.
Okay. Great.
All right, and then thinking about the new addition around underserved and kind of the concept of routinely underserved. One of the, we were trying to think about what that would look like in reality. And in the funding report, there was created this idea of a 3-year look back, which I think we can agree is appropriate, gives us a broad, a sense into multiple years, kind of bridging areas where different funding might have come into place. However, I'm not sure that it works in the underserved context. And I'll give you, a specific example. So if if we have a community with a significant, a municipality with a significant portion of their community being environmental justice population, and we may, based on that 3-year study, may list them as underserved from a, say, a clean, like a drinking water perspective, because 4 years ago, we granted them and gave them a loan for a massive refurbishment of their source and treatment, and what other options might be in place that wouldn't be caught in that 3-year review, when in reality, they have a state-of-the-art system that will be good for X number of years into the future. And I want to make sure that we are able to account for a span beyond a 3-year period if we're going to be thinking about it from a broader, like a holistic environmental benefit standpoint. Because it wouldn't align with reality, kind of a common sense view of whether or not they are appropriately served.
And I suppose if you're talking about 50-year infrastructure, having it be 4 years old is, you would miss it, but it's actually a very meaningful investment for decades to come. Okay.
If I may suggest a friendly amendment that
Okay.
could resolve that. I think when I drafted this, I think I didn't intend to preclude the agency's analysis to just looking at the baseline spending reports. So one way you could change this is to just make it so that they take into consideration the baseline spending reports as one factor in the assessment of whether there are municipalities that are being underserved.
I think we would also, if I can add a friendly amendment to your friendly amendment, it would be we need to allow for sort of consideration of the kind of 3-year average spending, or the sort of average spending across 3 years, have that be a consideration and not be the basis for a finding of a community being underserved as well.
Yeah, that's exactly what I'm saying.
Yeah.
It's a factor, a consideration, not the determining factor.
So I would propose, Senator Bray, that we work on some language for you, and we can consult with Ms. Mahaly and get back to you on what we think that language should be to meet the intent of
Okay.
the committee on this work.
Great. And thank you. And when you send it to me, can you also send it to Ms. Chakowski as well?
Of course, we will send all of those kind of edits at one time.
Great, thanks.
So, and then thinking about the rulemaking section, the 6003, and the conversation, sort of the bigger conversation around approval, teeth, consultation. I do want to start at a starting point, reiterate the firm commitment of the Agency of Natural Resources to fully engage with the council to consider that the rulemaking development process is an iterative conversation that they should inform and participate in. What we have laid out in front of you, and I think what you've been struggling with, is sort of this would be an indication that the current Administrative Procedures Act process is inadequate to give sufficient voice to sectors of the population. I'm not sure that this is an appropriate solution, and to Senator McCormick's suggestion that there be a rebuttable presumption, I think that gets into some pretty challenging grounds as we work through what the Administrative Procedures Act work looks like. And I think that if you are going to do anything in this space, it should be it should be an adjustment to the Administrative Procedures Act, not to solely exist within this bill. I still think that the process that we've laid out, that you've included here, included in this draft, is appropriate, and that we're supportive of, and we encourage you to move forward with this language.
Would it be anything? Would it be a potentially meaningful improvement to either side if, when the agency reviews the comments of the council, that they provided a written response to those suggestions? I mean, I see this in LCAR all the time. There's public notice, there's comments, and then the agent, one way, I suppose it helps LCAR, it helps all parties actually to see for what reasons either a suggestion was adopted, because the comments go both ways. Sometimes they say agreed, and then there's the new language inserted. And sometimes it's we disagree and it's for this reason. And then at least you know that it was heard and formally considered and then formally responded to. So I don't know if that improves the notion of consultation as opposed to someone politely listening, but someone feeling like, well, in the end, we were ignored. And you know, and what's making this so hard is that we're prejudging the sort of level of satisfaction of advisory council members prior to going through the experience. So we don't really, I don't know that we have a record to judge by. So let me boil that down for Commissioner Walk. Would it be workable to have written comments back to the advisory council from A&R as part of that review cycle?
Certainly, speaking for A&R, we would be more than happy. We provide provide a summary, written summary of response to comments for the standard public comment notice and comment process, and we'd be happy to provide those same written comments back to the advisory council for their consideration of the way in which we've either addressed or not addressed or resolved around a different concept, any comments that they may have.
Right. Ms. Mahali, with whom I think, even though I can't really play poker very well, and now I would like to play poker with. So what's your response to that notion of sort of firming up the formality of the review, comment, edit prior to going to APA?
I don't think that addresses the concern that I've heard from stakeholders, partly because, that's really not any different than the way that formal rulemaking already happens. When you have agencies have to issue a response to comments document after public comments are heard. So what you're proposing would just make them have to do that first with the advisory council, and then they would submit the rule to LCAR, and then there would be a public process, and then they would have to respond to all public comments in writing. So I don't actually think that I think it's just it sort of solidifies us into the process that we have that hasn't really ensured that they're truly heard. Heard is not the right description. I think it's about incorporating feedback into the final outcome. And I would just say, it's not a reflection of the APA necessarily being inadequate so much as us acknowledging that this is an area where an added buffer of protection and a nod of support for the task that we're asking the advisory council to do here is what we're doing. It's not an attack or a statement that the APA is not functioning correctly. It's us saying, in this instance, we think it is so important that we're going to give this added layer of influence.
Okay. Well, so I don't know that we're going to resolve this here unless someone's feeling like there's, oh, a eureka moment coming. Yeah, to your comment, I don't usually, I don't want to be debating, so I'm just offering an idea. And in response, as you're saying that, obviously, I doubt this will be satisfactory. It does strike me that creating the council itself, talking about funding, not just per diems, but stipends, giving them an intimate sort of seat at the table, working with the interagency committee and participating in the rulemaking is a substantive recognition and way of leaning in on this, even if they don't have the legal authority to to deny a rule from being introduced to the APA process. So anyway, that's just because I think of all the other parties that are involved in all the other kinds of rulemaking for whom there is no recognition formally, nor any kind of support in participating. So, this may not be enough yet, but I do think it's somewhat extraordinary that they're named, appointed, funded, and formally engaged in the process. So
If they are funded, if that ends up coming right now, I don't have that guarantee beyond the per diem. So I think I'm leveling this concern without knowing whether these members would be getting a stipend. I think if that was a guarantee, it might be a different story. But knowing that there's multiple ways, as you said, to show an advisory council that we're serious about the work that you're doing.
mm-hmm.
Giving them is one way. Giving them voting approval is another way. And so I would just advocate that the committee make sure that there are ample ways. And if funding is the way that it happens, then we need to just make that clear.
Okay, all right. Well, thank you. I mean, this is, like cooking live in the kitchen. So we're figuring some things out by talking about them together. So thank you. So Commissioner Waugh, back to you. Other sections of the bill you want to draw our attention to?
The last piece that I would just add on in section 3, page 12, or excuse me, page 21, line 12, talks about the first report of state agencies being due, I believe, on July 1, 2023. Or July 2023. Generally speaking, that report isn't, well, it's not timed very well for your purposes, in that I do not mean to be dismissive in any way, shape, or form of the legislature, but you are not paid to operate on July 1, 2023, July 1. So, and there will be, given the processes that we'll have to have played out by then, I think the report will be relatively light. And I wonder whether pushing that date back might make some sense so that you have the information you need to adjust anything in the coming session, rather than have it be 6 months out of date by the time you get that information back. So our typical reports to you are due more like December 15th or January 15th,
Right.
So that you have some ability to reflect on those as part of the legislative process.
Okay. When you send your revised timelines, I mean, there are quite a few dates in here. They all ought to, I myself sometimes make a chart and mark them all on it because it's hard to keep track of dates just in text. And so, sure, please, feel free to suggest any date changes on sections that you think makes it more functional.
Great, thank you. And that is the extent of our comments on the bill. Other than the reminder that your section on funding still awaits JFO's contribution to the cost.
Okay, great.
Senator Bray, may I add one other piece of reflection before you move on? This just has to do with funding, and I wanted to suggest potentially including language somewhere in here that authorizes the council to receive public or private dollars. I think there has been examples in other states where a foundation has wanted to support the important work of state government wrestling with environmental justice, and those foundation dollars could go to helping pay the stipends. And in the research that we did, looking at other states and examples of where commissions or councils have been paid stipends, that is language we saw in the authorizing statute, is a reference to, and I believe I sent you some language. I just wanted to, on the record, suggest that potentially be included in this bill.
Okay. Sure. Thank you for that offer. I mean, we do need to work out the mechanics. And one thought I had about that was because this begs a much larger question about how we support people who contribute to all sorts of boards and panels, recognizing that the per diem is a challenge for many people. If they have to take a day off from work, they're most certainly coming out a loser on payroll for the day. So rather than open that entire conversation, one thought I had was, if A&R were to see the advisory council as a group of contractors in some way, and so it was actually money allocated to A&R that A&R would then use to support a work group, you could call them consultants of sort. So it's more of a business construct, but it makes it a more contained way of addressing something without opening the question for all boards and panels and per diems and support for those who contribute. So I'm sharing an idea that came up in only the last 24 hours. So we haven't discussed this yet, and I don't know how that sounds to Commissioner Walk's ears.
To my ears, I think that is a fraught
Okay.
issue. One, fundamentally, the advisory council should not be in a contractual obligation to the state of Vermont, right? They are serving as a volunteer body that is providing us with input, and to feel that their finances are beholden to the happiness of the state and their participation is just not a good idea from my perspective. Okay. And I think that question and the question that Ms. Mahaly has just raised is a reflection of the inadequacy of the support provided to such advisory councils and such volunteers who work on behalf of the state. And so any sort of workaround that either speaks to a contractual obligation or some other way of paying for their time and expertise, or allowing for a foundation or other such body to provide support, to me just reflects that we're doing an inadequate job of supporting them in their work. And I really don't like workarounds to find solutions that just create muddier waters down the road. Okay. And so that's the reflection I would just leave you with.
Okay. Well, I'll send that back to the Department of Short-Lived Ideas and tell them to file it. Senator McDonald, you have something on your mind? Usually when you get close to the microphone, that means the wheels are turning.
Just getting close to lunch.
Okay. Well, any other, so let's continue to think about that, channels for stipend. So Ms. Mahaly, thanks for sending over language. Well, I think you're right. The bill needs to at least provide the outlines of something so that people can start to imagine how it would happen. Otherwise, I don't know how we pull it off unless it's entirely private philanthropy or something sort of outside the bill. And that doesn't seem like a very secure way of addressing it. So any other last thoughts or any committee questions for Senator McDonald?
I apologize. I had to leave and go to transportation. So to speak to them on a couple bills, but what stage are we with the bill before us?
Thank you for that question. So my hope is that we will sort out the open items we just went through in the last hour or so. We'll have a new draft for Thursday, and that we'll be at a point where we feel comfortable moving the bill. There's always a possibility on Thursday that we see something that we say we need yet another round. It's also possible we could get all the language nailed down by Thursday in a satisfactory form, but want that fiscal note that we're not going to be able to get till Friday. I'm going to see if I can get a preview on before our committee meets on Thursday, but so maybe we don't ship it and we actually delay the vote till Friday, till after we've had the note. But content-wise, I'd like to see us wrap up by the next time we go through this on Thursday and be ready to vote. So thanks for that question.
I ask it because I viewed this bill as trying to prioritize the assistance and our resources to people who are overburdened and underserved. And I think that probably represents about 65% of the population of the state. And then I look at the bill and I see that we keep subdividing that group of underserved and overburdened to a narrower population. And it just strikes me as worrisome. And would wonder if we're not going to be dealing with backlashes and things like and focusing on who does this serve 65% of the people in the state, or does it serve a small percentage, and will it be misinterpreted by the citizenry? So
okay. Well, so to just answer your question, and we have other people who can chip in here. So my shorthand for the answer would be that the maps we have that I don't know if you've looked at those. If I could ask, if Jude could please send them to you again, or get them, maybe even better, send them to the print room so you'd have copies of them, hard copies. And then I think numerically those three criteria together yielded a number of something like 52% of the population of the state of Vermont would be identified in the initial definition of an environmental justice population. So between the
that would be
maps,
helpful. Thank you.
I think that's our working answer, and that would evolve over time. All right. So I'm looking to Commissioner Walk and Ms. Mahaly. Do you want to add to that definition of maps plus 52% equals the current target audience?
No, I was gonna email Senator McDonald afterwards the exact thing that you suggested. So that's helpful clarity.
All right, great. So thanks for the question on timing and process. And if there are no other Senator McCormick.
Thank you, Mr. Chairman. You had said that you would like to at least possibly mark up and vote by Thursday.
Mm-hmm.
And I'm looking at the agenda, and our last witness is scheduled for 10 in the morning, and we have a joint assembly at 10:30. So I'm wondering if we're leaving ourselves time to give full consideration to all the witnesses.
Well, I think the open question related to the last witness is, okay, is over membership in the council versus the interagency panel. And I think it's a relatively discrete edit one way or the other. So I think it's something we could probably accommodate. But of course, if we're feeling rushed for time and we need the extra round, we have time available to us on Friday to come back to the bill. So we
Yeah,
won't.
just my sense was that if that was really the chair's intention, and I didn't want to suddenly, throw a monkey wrench into the works at the very last minute. I just want I expect I'm going to want more time than Thursday.
Well, I'm gonna talk to your housemates and ask them to take away your monkey wrenches meanwhile, but anyway, we have Friday always as a backup day
Okay.
if we need it. Okay, so with that, thank you everyone for coming in. As usual, I'll work with Ms. Chakowski and we'll look for edits from ANR. We'll look for additional language from CLF. We'll work with the edits we picked up in committee today and create a next draft for our review on Thursday.